Good morning. As you're logging in, we'll be starting in a moment or two. We'll just allow time for everybody to get logged in. Thank you. Good morning. We're just going to allow one more minute to allow other participants to get logged in, and then we will make a start. Thank you. Good morning. So you're very, very welcome to this latest in the series of Selig webinars with CEF. We're delighted to have the support of Selig as our legal patron. And this is just the latest in a long series of very topical matters which they've brought to our members over the last year or so. And just to remind you, all of these are available recorded on our CEF YouTube channel. And after this webinar, you will get a link to today's recording as well. Today, we're talking about protecting your intellectual property, your branding, property created by your business, for your business, and how to protect it from competitors, and so on. We're joined this morning by two of the partners from Selig. We've got Kirsten Magee and Watterson. And during the webinar, if you have any questions, I would ask you to use the Q&A function, which you'll find at the bottom of your Zoom screen. In the Q&A, you can enter questions, which we'll pick up at the end of the presentation on your behalf. And please do make use of that function. And I know Selig will be happy to take any queries today or indeed afterwards if you have any further thoughts. So with no further ado then, I will hand over to Glenn, who's going to introduce the session this morning. Glenn, good morning. You're very welcome.
Morning, Mark. Morning, everyone. Mark, thanks very much for having us again. Just a quick introduction on Selig. I don't know if any of the attendees have been on any of these webinars we've been running every month before, but Selig is a local and independent law firm based in Belfast. We have particular expertise in business law, so all matters of corporate and commercial law. We have a holistic sort of 360 approach where, no matter what your problem is, we bring together a whole range of expertise to fully advise your business on whatever your needs and your legal problems are at any point in time. Today, we're focusing on intellectual property. Now, that'll fit into the construction industry, mainly in terms of probably processes or formulations or things like that any of the attendees or any of your members may have. What we usually get asked is, to start with, is what I have intellectual property? What is intellectual property? Do I have the possibility to have what I've invented or what we've created protected? Should we register it? What do we need to do? Those are just some of the basics. Intellectual property refers to sort of all material created by a party by mental power. So, for instance, it could be a piece of art, song, images, inventions, designs, the way something looks, symbols, names, logos. As I said, in the construction industry, it's probably most likely from my experience, formulas. It could be a product that's added to something, a process that's created in terms to make a different sort of building material, things like that. That would be from my experience. The first bit of advice I would give is in terms of protecting your IP, is that once you've developed and expanded your own IP, it is very important as early as possible. If you think, look, this could be protected, or we're worried about somebody else knowing about this or trying to copy this, it would be to seek legal advice from a lawyer as soon as possible, just to assist with the identification, protection, and how you're going to exploit it and what you need to do once you've created it, to ensure that you can, one, not have anybody else creating or copying the same thing, but also to seek a commercial benefit from it. Apart from protection, it's also important to undertake that exercise to make sure that you're not unintentionally infringing someone else's IP, which could end up being a costly mistake if somebody brings proceedings against you, which Kirsten will talk about in more detail in terms of that enforcement piece after myself. So providing that this piece of property, this piece of intellectual property is truly marketable, you can create additional revenue by selling it or licensing it, as I've touched on. Franchise and merchandising are common examples of that. On the protection, that there are differences between unregistered rights and registered rights, and there's 4 types of intellectual property that I'll move on to in a second, but some of them don't require actual registration. But if you do go to the Intellectual Property Office, part of the UK government, sort of the office that deals with the registration and protection of intellectual property, and you register it, you have sort of a better standing in terms of enforcing any claims you may have arising out of your IP. So there are 4 principal types of IP. They are copyright, trademarks, design rights, and patents. Starting with copyright. Copyright's an automatic protection. It doesn't require registration, although you do have the ability to register for additional protection. It safeguards original, literary, dramatic, musical, and artistic works. So that could be, a book, a manual, songs, things like that. Songs aren't going to be too relevant to the construction industry. That result from intellectual effort or creative skill. Copyright exists as soon as something is written, as soon as it's created, but the date of creation, if you haven't registered it, it still needs to be proven in court. So we would always recommend, if it's the ability to register it, that's done. You can use a copyright symbol immediately. You'll be used to sort of seeing that C with a circle around it, immediately upon it being created, as a method of informing other people that you intend to exercise control over it, over its production, its distribution, its display, and or the performance of the work. Trademarks, which will be a lot more relevant to the construction industry. Trademark is a sign or mark which can distinguish your goods, your services from those of competitors. So that may be a brand logo, it may be the words, like say Selig, your legal team, underneath our logo. It could be a combination of both of those. Trademarks are used to protect slogans, symbols, logos, and brand names, all potentially high value marketing tools. And common law grants you some protection, providing you've got sufficient goodwill. So if you haven't registered your brand name, if you've been creating goodwill, and there's goodwill attributed to that in your accounts, then there is protection. But for added protection, if you haven't actually got to create that goodwill yet, and it's going to be some time until you do create it. So if it's a new business within your company, we would say, and it's going to take some time to create the goodwill, we would be saying, look, get that registered as soon as possible. Design rights. Design rights relate to the object's appearance. So if you've created an object, maybe the chassis of a car or some new shape of seat or something like this, it'll be protected automatically by design rights. However, if your design is infringed, the burden is on the person creating it to prove that the person who's copied it did not come up with the design independently. It was just, I suppose, by accident. It's better to register your design, because that protects it for 25 years and gives you the right to sue the person who's come up with a potentially infringing design, whether or not that was intentional or not. Finally, patents. Patents will be quite relevant to the construction industry. If you have developed a new or better product or process, and that is unique, it's useful, and it's non-obvious, you'll want to protect the competitive advantage that it provides by getting a registered patent. We don't always tell people to get patents, and I'll go into that a bit more detail, because when you do register a patent, it's out there. You have to submit drawings, you have to very internal workings and diagrams and everything get registered with that, and people can see it, so they know, well, we can't do that. But it does then leave leave the process or the invention open to reverse engineering. Now, patents typically you're talking 10 years for a patent, and then you can follow up for 10 years. But once that expires, it's out there, it's gone, and anybody else can create it, and there's nothing you can do about it. People can obviously, infringe it anyway without you knowing about it. In advance of that, they may reverse engineer and just create something, and you don't know they're another part of the world, and it's affecting your goodwill. You can only patent an invention if no one else has already done so, and once protected, its details are published, as I said. Registering a patent is a very time-intensive, a very technical and an expensive process. So as I said, it's because of that reverse engineering ability and everything getting published, but also the time and money that it takes to register, we don't always recommend it. The process of actually registering it, we would also, it's not something a law firm's going to offer in Northern Ireland. We would be referring you to one of the patent attorneys in Belfast that we would sort of work alongside to go through that process with you, because it is very technical, and those sort of firms that have engineers as well as patent attorneys working for them. In terms of where you're protected once you've registered your trademark or your other types of intellectual property, UK registration of your IP doesn't mean it's safe all around the world. Trademarks need to be registered in each country where you want to protect them, although it is possible to retain a registration over the whole of Europe. Well, it would be the European Union, so you would need UK protection. You would also need the European Community Trademark, as it's called. Designs similarly need to be registered in each country where you want to protect them, although again, it's possible to obtain that European protection for the whole of the EU. And in terms of patents, it's a country by country basis. There's no sort of consolidated European registration for those. Once you've registered your intellectual property and it's protected, there are other sort of more legal basis for you, to protect that further, to commercialize it. The one thing we would say is make sure you don't infringe anybody else's competing IP, because you're going to be open to being sued for a claim there. You can use patent searches, trademark searches. They're all sort of available online, and as I said, there are companies in Belfast that would run those searches for you at a small cost. So if you're developing a new process or anything like that, it's important to go and have a look, or have somebody do the research for you. Keep a log, evidence and recording the development of your intellectual property, so you can prove when things were created, how they were created, if there ever is any difficulties with any sort of claims that come down the line. Make sure everything's dated, time stamped, and that sort of stuff. In terms of your employees or even your independent consultants, if you have people coming in to create products or any other sort of IP for you, we would recommend that the contracts of employment of all your employees and the consultancy agreements of third-party contractors have intellectual property clauses in there saying that all rights and anything they create belong to your company, your business, and that those employees will waive all what's called moral rights, the ability to say, this was me that created this, and have that sort of credit, but also that the actual ownership sits with the company. The next point we'll talk about is non-disclosure agreements. You'll have heard of these. I mean, everybody comes across them. The amount of people that say to us, like, I need an NDA, I need a confidentiality agreement, it's very high. You want to make sure you're keeping your intellectual property a secret, and you only disclose it where there's a commercial rationale to do so. If the intellectual property is patentable, don't disclose it to anyone until the application's been made, to make sure it can't be copied regardless of non-disclosure agreement, just because of the way the patent laws work. Invest in NDAs, make sure they're properly documented, get a lawyer to draft those for you, and make sure you have sufficient protection if anybody tries to use intellectual property that you've created. In terms of commercialization, and also it does refer to protection as well, we would draft a lot of intellectual property licenses, that may be for software or for trademarks or copyrights and things, to say that you're giving another party rights to do certain things with your intellectual property. It may be use it and bring it into part of their business or part of their products, or simply to sell to other sort of maybe reseller agreements, things like that in terms of software. Again, they'll need to have protection clauses in there. They'll also deal with the commercialization. So, where can they use it? What customers can they go to? What types of industries can they sell? Can they use this for? And then, of course, you need to make sure that you're properly recompensed for this. So there may be sign-on fees and royalties and things like that. They're relatively, pardon me, complex agreements. And again, it's not something we'd recommend, but we have seen clients, that maybe even startup companies, maybe involved in software, that they've used something they found on the internet and it just hasn't given them the protection, and they're trying to sort of unwind things that have just gone too far for them. It's important also to monitor changes in the law. So the Copyright and Designs Act, intellectual property legislation, they do get tweaked from time to time. So it's just a matter of making sure you're on top of the law. And also review your registrations. If you go to the expense and the time of registering your intellectual property, of having the trademark, they don't last forever. There are finite periods on them, so it's important to make sure that you will get reminders sent out, but a lot of the time these sort of circulars just get thrown in the bin. So it's important to stay on top of your protection and make sure that you're suitably covered, and you can renew them when they're needed. So I'm going to hand over to Kirsten now, who's more in our partner in our litigation team, who more deals with enforcement. So what happens if something does go wrong, or somebody's infringed your copyright, or you infringe somebody else's copyright or other intellectual property.
Okay, thanks, Glenn. So Glenn's covered all of the positive aspects of IP and how it can make you money. And so typically, as a litigator, I'm here to tell you what happens when it all goes wrong. A little bit of doom and gloom. So basically, what can you do if someone infringes your rights, and what if you're accused of infringement? What can we do to help you there? So look, I'm going to revisit the sort of 4 main types of intellectual property rights and look at the issues around infringement in respect of each one. There's a lot of law in this, which I'm not going to go into in a huge amount of detail. You'll be glad to know. I'm going to keep it quite high level, but it is a very technical area of the law, and as Glenn says, it develops a lot and there are often tweaks. There's a lot of case law around it. So it is pretty complex, but I'm just going to give you a sort of high level view of things. So starting with copyright infringement. So we know what copyright is. It's infringed if someone uses the whole or a substantial part of your work without your permission, and where none of the exceptions apply. So for example, we think about copyright as being relevant only to sort of musicians and artists and creative types, but actually you may well find that a lot of the literature that you produce in the course of running your business could benefit from copyright protection, training manuals, trade literature, and the like of that. So if a competitor were to lift something from some of your material and use it themselves, then that would be in breach of your copyright. Now, it has to be a substantial part. So there's a lot of case law around what is substantial, and what it comes down to is it's not a quantitative thing, it's more qualitative. So it's really, is it the real product of your intellectual endeavor that has been stolen? So it is easier to illustrate these points when you look at the sort of musicians who have been in the press recently defending their copyright. So for example, Ed Sheeran and Taylor Swift. There's a good picture of Glenn and I. Ed and Taylor have both been in the press recently defending their position, where they've both been accused of infringement of others, the work of others. So you might have seen the recent news reports with Ed Sheeran's case. It's in relation to his "Shape of You" song. And in that case, there's a Northern Irish chap who co-wrote the song with them. Apparently, shape of you is if you're from Derry. I don't think it's a complimentary term, but it's somehow made its way into the song from him. But the part of the song that was being challenged was the sort of hook, sort of I'm really going to struggle not to sing it because and if you knew me better, I struggle not to sing at any opportunity. But it's the sort of oh I hook that runs through the song. There's a couple of songwriters who have a song called Oh Why. Didn't sound similar generally, but this section, which really is a sort of pentatonic scale, they claimed was stolen from their music. And there was a really interesting trial where we got a bit of insight into the songwriting process. So any sort of amateur songwriters out there, it was really interesting. But essentially in that case, it wasn't established. They hadn't taken, it wasn't made out that they had taken something substantial, and there wasn't held to be any intentional copying there. With Taylor Swift, case is still ongoing in the States in relation to her famous sort of earworm player's gonna play and haters gonna hate. There is another song out there that has a sort of similar lines. It doesn't sound the same in any way sort of musically in terms of the melody, but the allegation there is that she has been inspired and taken that sort of idea, players going to play, haters going to hate. So that'll be interesting to see where that runs. That's going through the federal court in the States at the moment. So moving on from that, in terms of remedies, what can you do? Well, you can make an application for an injunction to stop someone using your copyrighted work. You can seek damages where you've suffered a loss as a result of them stealing your endeavor, or an account of profit. So if a competitor were able to go away and take something that you have created and use it to their benefit, then you could look at, rather than looking at what you've lost as a result, you could look at what they've gained and try and cream that away from them. And you can also ask the court to order them to deliver up any sort of product that's infringing. Now, copyright infringement is sort of unique in that if it's carried out sort of deliberately and on a commercial scale, it can actually be a criminal offence, and there are criminal penalties that apply. So certainly want to avoid falling into in terms of your own activities. Don't be tempted to sort of lift anything that you see and just sort of slavishly follow it, because you don't want to open yourself up to an allegation of infringement. So moving on to trademarks and sort of passing off. Trademarks, the activity around this is probably what I would call sort of bread and butter intellectual property work in this jurisdiction, at least. I mean, almost every company sees the value in their brand and their name. And even if you don't have a registered trademark, you obviously, as Glenn's explained, you could have unregistered rights in your brand and your branding. And like a good chunk of what I would do would be to help clients who find that a competitor or someone has popped up using a similar name, or there's a concern that people will be confused and that they might lose some business to them. So yeah, it's probably the most active area. In terms of infringement, it's using a sign, which doesn't have to be a name, it can be a symbol, in relation to in the course of trade, in relation to goods or services, either where you're using an identical sign in relation to identical goods or services, or it could be similar in relation to identical goods, and then sort of further down the spectrum, similar signs, similar goods, and it sort of becomes progressively more difficult to establish as you go along that spectrum. So obviously, if you produce a new fizzy drink and you call it Coca-Cola, you're pretty clearly going to be guilty of trademark infringement. But you can see how products pop up that are it's pretty obvious that they're something they're trying to fly on the coattails of a large brand. And we'll come on to a good example of that. But in terms of the course of trade, what does that mean? Well, anything involving sort of applying the mark to a product or to a service, so marketing yourself as whatever, that's the course of trade. Offering up goods or services, importing or exporting goods that are marked with the infringing mark. So there is sort of scope to be sort of an indirect infringer in trademark infringement and a patent infringement, which we'll come on to. So it's not just what you produce, it's what you put out there into the market. So defences, quite often what you'll see is that if someone's accused of infringing a trademark, they will say, well, look, I was entitled to use that mark even though I haven't registered it, because I've built up a reputation in my sort of local area, and there's no risk of any confusion, so I shouldn't be penalised for using this mark here. Or they'll look to attack the mark itself and say, well, look, yes, this has been registered, but here are the reasons why it should not be registered. And there's a process where you can try and revoke a mark that has been granted. Remedies are very similar to copyright infringement, damages, injunction, accounting profits. But in terms of what can you do if someone is out there in the market using something that's similar to your branding, then we would quite often be instructed to issue what's known as cease and desist correspondence. And it's basically where you write to the infringer and you highlight the issue and you ask them to immediately stop doing what they're doing, under threat of proceedings. It's something that it could be tempted to say, well, sure, that's pretty straightforward, I can just deal with that myself. But please don't do that yourself, because they're, especially in relation to trademarks, you can fall foul of aspects of the legislation which are designed to protect sort of smaller businesses from the big bad Goliath business threatening proceedings where it's not justified. So that you can fall foul of those provisions quite easily. So it's not something to try yourself, but do come and speak to us if you have any concerns about someone using your mark or using a name that's similar. And just to illustrate the sort of trademark infringement, the issues that it throws up. Again, you must have seen this in the press. It was very widely publicised. The infamous Colin the Caterpillar, and who is Marks and Spencer's sort of real key product that children's birthday parties for the last 20 years have featured a Colin the Caterpillar cake. Aldi's version is Cuthbert the Caterpillar, and clear similarities in terms of packaging and the sort of look and feel of the product. The only difference being, the name Cuthbert as opposed to Colin. So Marks and Spencer's had 3 trademarks registered in relation to Colin, including the words Colin the Caterpillar, but also in relation to the packaging, they had registered protection. So obviously they decided. Now there are loads of other supermarkets that have Cyril, and I can't think of all the other names. There are lots of other supermarkets who have something similar to this. But Cuthbert obviously just went, a step too far, a slow step too far. So he had really, led M&S to just say, right, enough is enough. So they have issued proceedings against him. Those proceedings have now been settled. Unfortunately, the terms of settlement haven't been publicised. But I wonder whether a faction of that might have been the absolutely genius social media campaign launched by Aldi. You can see a couple of them on the slides there. Cuthbert has been found guilty of being delicious. So it was free Cuthbert and Marks and Snitches, and it really got the sort of public support. So I think Marks and Spencer's really, really difficult position there, where they were trying to decide, how do we, they obviously don't, they wanted to enforce their rights, but they don't want to look like, the big bad guys also. So there can be a little bit of an element of that. Trying to make sure that you do it in a way that doesn't make you look like you're stifling competition. But that case is resolved. But similar issues, you might find, and it's pretty common to find, particularly in the construction industry, descriptive names. What are you doing? What are you type of engineer? What is it that you're doing? What service you're providing? And that can make its way into your name, and therefore there can be sort of overlaps quite frequently between different contractors or organisations. So it is something to look for, and it can be pretty damaging if you are if you find that people are going to one of your competitors, believing that they're in some way linked to you. So it is a real issue, and equally, you don't want to fall foul of that yourself. So, look, moving on, the design right. Glenn touched on probably an area where doing what you do, you might benefit from protection, even inadvertently, without sort of realizing that you've done it. Designs, like defenses to an allegation of design right infringement, tend to go along the lines of, look, we've used this design for years and years in good faith, we didn't realize we're infringing. And if you have been using it but just not publicly, then that can assist any sort of private acts. Or if you're designing something, if you copy a design for sort of experimental purposes, then that's permitted. The remedies, again, are pretty similar to copyright and trademark infringement, where you can get injunctive relief or sue for damages, or again, account of profits. If someone's gone off and taken your design and made a lot of money from it, then that could be the most attractive of the remedies. Moving on to patents, as Glenn said, this is probably the most technical area, and it's an area where we would work as collaboratively with people who have more of a scientific background, albeit I do have higher physics and maths. It won't take you very far when you're trying to look at a specification for a patent that looks entirely in sort of, looks like calculus, looks like a calculus nightmare. So we do work very closely with patent attorneys, both in relation to the sort of process of registering your rights there, but also if there's any issue around infringement, because whereas in copyright, trademark, design right, it's usually fairly clear to the layperson whether there has been infringement, not so necessarily in relation to patents, where you really do need sort of scientific or engineering input to confirm whether there has been infringement. Like, how do you infringe a patent? Well, if you make a product that is patented, then if you copy the design, then you're obviously infringing. If you use the product or component in your own producing something new, then that's also obviously infringing. But you can, again, indirectly infringe a patent by importing something that infringes, or selling it on. Again, usual defenses, either this does not infringe is more common than in the other cases where you're saying there's no copying here. In patent cases, quite often it comes down to the detail of the specification of the patent and whether what your thing does it in exactly the same way. But also, again, you can attack the patent itself and say, well, look, yes, technically there's infringement here, but the patent should never have been granted, and here's why. And either because it wasn't novel, it wasn't new, or sort of obviousness. I've recently acted for a company who developed a piece of sort of heavy machinery, and in their mind they had refined the design of it over the years and decades, sort of organically, and they felt that each sort of new version of the product, they didn't really think it merited patent protection, because they felt it was just a sort of natural next step in the design. Whereas one of their competitors had gone off and got a patent in relation to one sort of feature of the machine, which was similar to theirs. So in that case, the client would serve with proceedings, seeking an injunction, account of profits, delivery up of all of these pieces of machinery. Obviously it was not a nice situation to be in. The first thing we did was we managed to negotiate a sort of standstill, whereby we agreed to hold the ring by giving an undertaking that we wouldn't sell any more of the machines at this point until we sorted things out. And we also then issued a challenge through the Intellectual Property Office to the patent itself, on the basis that we said, well, actually, this was just natural. There was no inventive leap here. This was this natural progression. So we did that. In the time that these things always take time, the commercial background changed to the point where my client really wasn't focused on this particular machine. It wasn't going to be wasn't their sort of flagship anymore. So we were able to sort of retreat from that by saying, well, we'll withdraw our challenge to your patent if you withdraw your proceedings against us seeking damages, because the damages were going to be substantial. So we managed to have it resolved on that basis, and my client agreed to disable one very specific function of the machine going forward. But look, those proceedings would have been lengthy and expensive. So main thing, I suppose, is to try and avoid action, keep abreast of developments in your industry. What are others doing? Who's got protection? Get a patent attorney to carry out a patent search for you, just to know what's new, and what, just to be careful in terms of what you're doing. But look, that really is a whistle-stop tour. That there are all sorts of issues, and yes, if you have any questions, specific questions, feel free to pop them in the chat, or if they occur to you later, feel free to drop myself or Glenn a line just to ask anything that's, oh, Glenn, you're putting your hand up there. I don't know if you mean to do that, but but if anyone wants to contact us afterwards, then our details are on the slide at the moment. And look, please do and have a think about it. It's not sort of something that immediately occurs to you when you're busy running your business, but there may well be scope for you to either look to protect what you have already, or you may feel that you need to come to me if there's a problem in terms of infringement. So feel free to do so.
Kirsten, thanks very much, and Glenn, thank you very much. That's really been really interesting. Only disappointed, Kirsten, we didn't get your Taylor Swift impression, but we saved that for another. I managed to
hold it in. Save it for another time.
Just a thought in my mind. I know a lot of our members are very creative, and particularly in terms of recruitment and staff well-being, and hashtags are a thing of the moment, aren't they? So everybody's coming up with what they hope are unique or bespoke hashtag, which will identify their business over another business. Is that within scope?
Yes, I mean, absolutely, especially in terms of websites and things that we're putting out on the internet. I mean, you have to be careful. You have to be very careful. Even in putting together this seminar, we were careful about the photographs, the images that we were taking. Now, there's an exception for educational purposes, but yes, absolutely. You can infringe a trademark by including someone's mark in a hashtag. So hashtag Aldi would potentially infringe Aldi's mark. So we do have to be careful around that. You don't want to completely stifle creativity. I think that is the key. As long as you are being creative, then you're fine. It's when you stray into just lifting from others. And like I had a client recently who, it was a sort of combination of the domain name. So someone had registered a domain name that was very similar to their business's name. And not only had they done that, but they had then taken content from our client's real website and just replicated it on their website. So, I mean, it was a rogue website, presumably designed to sort of, get customers to go off there. Who knows what they were actually offering, if they were actually able to do what they said they were going to do. But in that case, we were able to on their behalf, contact the domain name provider and challenge that, and we got the website taken down. So whilst we would have had an avenue to go down the sort of copyright infringement route, we managed to get rid of it completely. So that wasn't an issue. But yes, absolutely, all of these. It doesn't have to be written in a book or in a magazine article for it to be infringing. So yes, you just have to be mindful in these days of Twitter and social media that you still have the same obligations, but do try and be creative. That's the best way to avoid infringing, is to come up with something novel.
Just do a bit of Googling beforehand, and if you see anything obvious, maybe you take a bit of advice.
Absolutely.
Fantastic. Well, folks, I don't think we have any actual questions coming in, but your contact details are there. and we will share them after this as well with everybody who joined us today. So I will thank you again, Kirsten and Glenn, for your time. And as always, thanks, Selig, for all the support we get from you. As our legal patrons, we're delighted to have you on board. And as I say, this is only the latest in a long series. These are all on our CEF YouTube channel, and we'll share that with members as well so they can catch up if they've missed one. But for today, thanks very much for your time. Thanks everybody who logged in to join us, and we'll see you at the next one. Thanks very much.
Thanks, Mark.
Thanks, Mark. Cheers.